We're going to start with a 10-minute take at 200 words a minute. Okay, this is literary. Ready? You step in a puddle of spilled cooking oil in a grocery store and break 3 bones in your hand. You're a concert pianist. How can you recover your lost income? Your landlord claims you broke several things in your apartment that you didn't pay for. You know they were broken when you moved in. The forms you sign when you moved in don't specifically mention those items. How do you keep from having to replace something you aren't responsible for? Lawsuits are filed every day. In fact, according to an article on the Citizens for a Sound Economy website, there are more than 15 million civil cases processed annually in state courts alone at a cost of over $1.8 billion. Although the number of product liability cases in 2000 was less than half the number in 1997, the courts are still clogged with civil lawsuits. Most courts are trying to encourage people to settle their disputes out of court, and some require mediation at some point in the process before you can go to trial. In this article, we'll talk about what you have to go through to take someone to court, or what you might be able to do to avoid court and still get some satisfaction. Keep in mind that the legal process differs from state to state, so this may not always be exactly the way it works in your area. Civil versus criminal. First, let's start off by establishing that there is a difference in a civil trial and a criminal trial. When you sue someone and take him to court, it is usually based on a tort. When someone breaks a criminal law, then the public prosecutor takes him to court for a criminal trial. Torts are different from criminal laws in that a person may not have broken a law but may have acted negligently, either intentionally or not, and as a result someone else was injured physically, emotionally, and/or monetarily. Torts provide grounds for the lawsuit. Specific torts include trespass, assault and battery, negligence, product liability, and intentional infliction of emotional distress. There are also 3 general categories that torts fall into: intentional torts, for example, intentionally hitting someone; negligent torts, for example, causing an accident because you didn't follow traffic rules; and strict liability torts, for example, being responsible for damages caused by a product you manufacture and sell. The original purpose of tort law was to compensate victims for their losses, and also to help prevent future losses by punishing the defendant, the person being sued. For these reasons, there are compensatory damages, which require the defendant to pay back money the plaintiff, the one who filed the lawsuit, lost as a result of the defendant's negligence, as well as money to make up for pain and suffering. There are also punitive damages. Punitive damages are what the defendant has to pay as punishment for being grossly negligent, malicious, reckless, or acting intentionally, not just making a mistake or not being careful. In an effort to get a handle on the rising punitive damages, a decision was issued in July 2003 by the U.S. Supreme Court that limits the amount someone can recover in punitive damages. The steps. If you are intent on a lawsuit, here's a quick list of the steps you'll go through before it's all said and done. Try to settle out of court. File the suit. Discovery, pretrial motions, and discussion. Settlement discussions. Trial and judgment, appeals. We'll walk through these steps one by one. Settling out of court is far less expensive than a trial. Unless you know for a fact that you have an ironclad case, you stand the risk for spending large amounts of money and getting nothing in return. No satisfaction, no restitution, nothing. The best first step to any potential lawsuit is to try to work out your disagreement outside of court. The courts agree with this wholeheartedly, and in some states require some sort of dispute resolution before you can even bring a case to trial. Even if you do have an ironclad case, you need to weigh the costs of litigation with the potential award you might or might not get after the trial. Here are some ways you can try to resolve your dispute without involving lawyers or large sums of money. You have 3 general paths to take to avoid the courtroom. First, you should try a good old-fashioned face-to-face conversation with your adversary. Is he even aware of the problem? Does he acknowledge responsibility? Have you tried to come to an agreement about how to remedy the problem? You may be surprised at how reasonable the person is. If you do come to an agreement, you should probably have it documented and each sign it with the witness present. And it's best to have an attorney drafted up to make sure you haven't left any loopholes. If you've tried your own negotiation and gotten nowhere, then you might consider mediation. In mediation, you and your adversary come together with a neutral third party who tries to help work out an agreement. A mediator does not have any say in how the mediation turns out. He only provides advice about your opinions and how you could come to a fair agreement. He helps you arrive at a solution. In some courts, you are required to go to mediation before you can bring a lawsuit to court. You don't have to come to an agreement, but you have to go through the process and try. This requirement is an effort to reduce the number of cases that go to court. Some contracts you sign may also require mediation before you can file a lawsuit in the event of a dispute. If you do arrive at a solution in mediation, you can make it legally binding by writing up a mediation agreement. Each party and usually the mediator signs. The agreement spells out the decision that was made as well as intentions for future behaviors that both you and your adversary are required to follow. By having a signed agreement, you can make the outcome enforceable in court. Mediation fees vary a lot. Depending on where you live and who your mediator is, you may pay as little as $50 or nothing for mediation, or you may pay $200 or $300 per hour. Mediator training varies a lot too. Some may be volunteers who have background in social work or similar fields. Some may be specifically trained for mediation in specific areas like divorce, social work, and some are lawyers who mediate on the side. Another form of dispute resolution is arbitration. Arbitration is similar to mediation in that you come together with your adversary and a third party to discuss a solution to your problem. The difference is that the third party, known as the arbiter, makes a legally binding decision on your case. Arbitration is more like litigation in this respect. You lose control of the decision. The arbiter's decision is called the award and has to follow the law. If the arbiter doesn't apply the correct laws to the decision, then the judge may overturn it. You are also allowed to have counsel at an arbitration. If you know your adversary is bringing an attorney, you should too. So when should you go to arbitration? Since arbitration is based more on the legal issues and less on the personal issues of the case, it is usually recommended for cases that involve money, rather, as opposed to a case about a neighbor who keeps blocking your driveway. Cases like that are best settled in mediation if possible. Arbitration does cost more than mediation, however. It is still less than going to court. Like anything else, it depends somewhat on where you are geographically. Typical half-day arbitration may cost both you and your adversary anywhere from $500 to $1,000 each. There are different types of mediation and arbitration. For instance, you can have non-binding arbitration, which means that if either party doesn't like the decision, it isn't binding. You can opt for high-low arbitration, which means that you and your adversary establish upper and lower limits for the monetary award. For instance, an insurance company would suggest a low amount and the individual with the complaint would suggest a higher amount. The arbiter isn't told the limits. If his or her decision is lower than the low number, then the low number is used. And if it is higher than the high number, then the high number is used. If the decision falls within the limits, then it becomes the actual amount of the award. Many other variations are possible as well. For more information, you can look at private dispute resolution. If neither mediation or arbitration works for you, then you begin your search for a good attorney. The best bet is to get recommendations from friends, family, business associates, or the local bar association. You should talk with several attorneys before you settle on someone. Look for experience in the area of your dispute and litigation experience, as well as interest in your case. If you need a very aggressive attorney, then watch the attorney in the courtroom and get a feel for his style. How well you get along with the attorney is also important because communication between the two of you is crucial. If you don't feel comfortable with the person, you may not be able to communicate with him effectively. Also, remember that in the event that you make a poor choice, you can always change attorneys. You would still have to pay any fees and reimburse for costs, and the initial attorney might have a right to part of any award you eventually earn. If you've determined that a lawsuit is your only option and you've found the perfect attorney to try your case, then you're ready to get those legal gears turning. In this first stage of the lawsuit, known as the pleadings, your attorney writes a document called the complaint that describes the basic facts of your case, names everyone involved, references the legal theory to back up your claim, states what you want as the outcome, money, an agreement of action, etc. You, the plaintiff, and the person you are suing, the defendant, are known as the parties to the lawsuit. There can be more than one person on either side of the suit. In fact, there may be many defendants and many plaintiffs. For example, you and some of your coworkers might decide to sue the company that you work for. If you all have the same complaint and seek the same outcome, this will work out fine, and you will all save money on legal expenses. If not, you need to file separately. In cases where there are potentially hundreds of plaintiffs, then a case action suit may be considered. There are two court systems in the United States, state court and federal court. If your case involves someone from another state, known as a diversity case, and has a value of over $75,000, then it may go to federal court. If your case involves some sort of federal law or right, it can also go to federal court. Federal question is more fully defined as jurisdiction given to federal courts in cases involving the interpretation and application of the U.S. Constitution, acts of Congress, and treaties. Other than that, you'll probably go to state court, unless, of course, your case involves both federal and state laws, in which case you could go to either state or federal court. How do you determine where the suit will be filed? If you are seeking monetary compensation of less than $5,000 in many states, you can take your case to small claims court. In small claims court, there is no jury and you can't bring an attorney, although you may meet with one prior to the court date.